affidavit erroneously contains all our time entries for the motion to dismiss. I've racked my brain trying to figure out why, because it was our intent to remove those. I even called Mrs. Harrison to see what her recollection was, and hers was like mine, that we had adjusted the fees to reflect that reduction, right? But the end product, the bottom line is that the end product I'd filed, Your Honor, does not contain that reduction. I can only conclude that we got the numbers confused because maybe we were working on the two affidavits simultaneously. All I can say is I can assure the court it was an inadvertent error and that it's, I'm sorry about it. It's on me. I was the lead attorney, not Ms. Harris.
So put that in numbers.
Yes, I will.
What I had originally was that, and I know some things changed from when Ms. Niles helped me with a summary of the case because something, maybe the wrong cutoff date was used, but sure. Roughly, you were seeking, Mr. Pastel, under the offer of judgment, $48,000, and under the frivolous litigation, you were seeking about $27,000, give or take. What's different now? Okay,
so if you recall the motion to dismiss, kind of as I said last time, I still view it as having three categories of claims. The one that the prior trial was perpetrated by fraudulent evidence. The second is the defamation issue, and the third is the overpayment of assessments. Now, interestingly, Ms. Harrison and I had just won an appeal on the overpayment of assessments. So on a different matter, so we had that research ready to go, right? So really, the time entries all really, for the most part, involved those other two claims, right? And I would say conservatively that we spend at least 50% of the time on what I have coined as, let's say, the prior trial was by fraudulent evidence. Right? And the reason for it, Your Honor may recall, those were unusual claims. They weren't like spelled out as claims we normally come across. And the procedure setting wasn't where we normally see it. I didn't see it as a motion to, change the final judgment that I've seen before and stuff. So that's why I can say I really feel like we spent the bulk of our time, at least 50%, on that first category of claims. So that would mean that, being conservative again, we could remove the defamation and assessment claims being 50%. So that would reduce this motion in half. I can give you the exact number if you want, but it's essentially 13,500.
Okay.
So
and have you provided this mea culpa to Mr. Downs or Mr. Johnson before right now, or is this the first they're hearing it?
This is probably the first they're hearing of. Well, this is definitely the first they're hearing of all this, Your Honor. I have. In the providing of the materials, I noticed that I did note, I said that I had thought there was more entries deleted than what I had said, So I didn't want to hide this fact, but I hadn't worded exactly and finished looking into it as deep as I could at the time I forwarded all that information.
Okay, so let me see if I can play this back and understand it. You are effectively having the amount of fees sought under your 9-15-14 motion because you have come to realize that the bills that you sought to recover pursuant to 9-15-14, which you had explained when we were last together on the 18th, were all predicated on the counts that were dismissed, the counts that related to this, bringing the first case was a fraud. unintentionally, inadvertently, you included in the billing records that yield the 27,000 figure work you did for either category 2, the defamation pieces, or category 3, the overassessment pieces. And you have since gone back and rescrubbed, and you now believe that a more accurate figure that would represent money spent, bills paid by your clients for the work done on the part of the case that got dismissed is give or take 13.5. Okay. All right. I now understand what you were describing. I just got an email about an emergency that I need to deal with. I'm going to be gone for about 4 minutes because I have to make a phone call. We're going to leave this going. I'm just going to make my screen go to non-video and I'll mute. It may be that Mr. Downs and Mr. Johnson want to mute and get on the phone and talk to each other for a minute because of this, sort of a natural point to break. When we come back, I'm happy to hear from Mr. Downs or Mr. Johnson about whether you still want to go forward today or if you need time to digest this. And then Mr. Barr, I'll see if there's anything you want to add. Assuming we're going to go forward with today, then we'll pick up with Mr. Johnson interposing any remaining questions he has to Mr. Pastel. That work? All right. So we will be on a brief recess and I will reappear in about 5 minutes. Thank you.
Interpreted what you saw.
Yeah, a little bit.
That's worse.
They can still hear us. So. Might try us, you know, muted.
As good.
I'm back. It's nice seeing everyone reappear. There's Mr. Johnson. Okay, everyone's back. I apologize for that. We have a rather significant bond hearing happening tomorrow, and it is causing several judges to have to shift their calendars around, and I had to get in the middle of that. I will not be having the bond hearing, someone else will, but we're just trying to burden share across the judges in these complicated times. Mr. Downs and Mr. Johnson, did you have a chance to confer if you wanted to confer? And more importantly, are you comfortable going forward with this late breaking news from Mr. Pastel? Mr. Johnson, you're still muted.
Sorry about that.
No problem.
We are comfortable moving forward.
Great. Okay. Do you have any not under oath questions of Mr. Pastel about what he shared before we dive into it, or should we get him back?
Let's get him back under oath, and I don't think it's going to take very long.
Okay, that's what you had promised, but suddenly the landscape changed, so who knows? I promised this. Mr. Barr, do you have anything you want to add, or are you comfortable with us moving forward?
No, I'm fine with moving forward, Judge. Thank you.
Are your bills being cut in half also?
No, sir, because I did one under Rule 68. So
Okay.
I
Just
did,
checking. Don't want to
on that point, I did have a question, and this is just my potential ignorance coming in late. Matt, you did not join in or file your own 9/15/14, correct?
correct.
Okay.
That's right.
All right, then, Mr. Pastel, you remain under the oath you took when we were together last on the 18th of June, and we're picking up with the cross-examination by Mr. Johnson.
Thank you. Good afternoon, Mr. Pastel. Do you remember the last time I was asking you questions? I was asking about the defamation-related time entries that were on your invoices after the expiration of your 9/11/68 offer versus the defamation time entries that came before your 9/11/68 offer. Do you remember that?
No, not really. But I mean, I got the concept. You're saying that we have defamation entries after the offer after the judgment part?
No, remember, I'm making the point that you did not do any substantive defamation analysis until after your 9/11/68 offer was deemed rejected.
Right.
And I was arguing that your time entries around your motion to dismiss, which are also the subject of your 9/15/14 motion, those time entries lacked any real entries related to the analysis of Mr. Downs and Mr. Richardson's defamation claim. You remember me asking you questions about that?
Yeah, and I remember my response now was that there's research done. We did the 9/15/14 letter to Mr. Downs, and we had filed the section in our briefs, on the motion to dismiss for defamation, right?
Thank you. But my question was specifically about time entries on invoices. And do you remember, in response to my inquiries, this is where you first came up with the assertion that there were different invoices that had defamation time entries, but you removed them for the purposes of your 9/15/14 motion because you weren't seeking those fees because you did not prevail on the defamation cause of action. You remember that?
I do not recall that the necessarily sequence of it, but I specifically recalled when you asked me, did all the time entries for the motion to dismiss include all our work on the motion to dismiss? And I had said, that's when I said no, that's when I made my error. Right.
Well, I'll get to that in a minute, but your testimony was there were time entries that specifically related to defamation that were removed from those 9/15/14 invoices because you did not prevail on that claim, right?
Right, that's why I made my statement to the court here just before we started.
Well, and I want to be clear about your statement. It is true that the new invoices that you've produced to the court do not have any redactions related to defamation time entries, do they?
First of all, they're not new invoices. They are the first time they're being produced to the court, but they are electronic reproductions of the ones that went out at the time. And yes, as I said in my statement here, right, when we were doing our time entries on the motion to dismiss, prior to our prevailing, Your Honor, we did not segregate the cat into different categories of the claims we were working on. And now I've, reviewed that, and that's the case.
Okay, so I want to be clear, and I'm going to try to share my screen. Give me 1 second. I'm showing you what was previously introduced as your affidavit relating to your 9/15/14 motion. Do you see that?
Yes.
And if we look through this, there is a time entry on April 4th, 2016, and it's a block billed entry that says research issues of grounds to set aside the judgment, fraud, conspiracy, abusive litigation, intentional infliction of emotional distress, and defamation, 8 hours. Do you see that?
Right, and I believe that's the only time the word defamation is used in my affidavit.
So if someone wanted to look at your bills and determine when and where you analyzed Mr. Richardson's defamation claim, this entry is the only entry that they can see where any work on that defamation claim was performed, right?
It's the only entry that itemized, and it really doesn't even itemize because it lists all the claims there, but it's the only entry that uses the word defamation. Doesn't mean defamation wasn't researched in other entries.
Okay. So if I understand, you've said that several times now. So the way I understand your testimony is that if somebody wanted to look at your invoices to determine what work you did analyzing Mr. Richardson's defamation claim versus analyzing his fraud claim versus analyzing his overpayment of assessments claim, they can't do that looking at these invoices, can they? Because that time is not specifically spelled out in your invoice.
That's correct.
Okay. Your Honor, those are my questions.
Okay, let me follow up on that last little area. So I want to make sure I'm channeling how Mr. Pastel has broken things out into 3 categories. Defamation research ought not to be included in what you are seeking to recover via 9/15/14, because that's targeting only the counts that were dismissed pursuant to your motion to dismiss. Is that correct?
Correct, Your Honor.
Okay, all right. Those counts you triumphed on by way of the motion for summary judgment, the count or counts related to defamation. Is that right?
Yeah, you entered final summary judgment on the defamation claim. After a lot of discovery, he ultimately dropped his HOA assessment claim.
Right.
And
So those were withdrawn. The overassessment was withdrawn, and then there are 2 categories remaining. There is, I'm not going chronologically here, but the 3 categories you created were, this was a fraudulently based lawsuit, the first one. There's the defamation, and there's overassessment. Overassessment went away. The fraudulently induced lawsuit or procured lawsuit was tossed out by way of dismissal. And then the defamation, you, Mr. Pastel, triumphed by way of the motion for summary judgment, but it wouldn't be that's 9/11/68. That's, you gave this offer of judgment, offer of settlement, and it was not accepted. And then we got to the order granting summary judgment.
Correct.
Okay. All right. Mr. Barr, I don't know that you'd have questions of Mr. Pastel, but I need to make sure that every represented party here has a chance to ask questions of witnesses who are testifying.
No, thank you, Judge. I do not have any questions for Mr. Pastel.
Okay. All right. Then I think we're done with your examination, Mr. Pastel. Thank you. Today was shorter than on the 18th. Where does that take us then? Mr. Pastel has provided his testimony. He'll get a chance to provide summation at the end of today's session. Mr. Barr, I guess, are you up now to make the representations you need to about your bills and your billing rates? Is that where we go next?
I believe so, and I can do that now if you'd like, Your Honor.
I think that's right. Mr. Johnson, you agree?
Yes, Your Honor.
You're up, Mr. Barr.
Okay, well, Judge, it's good to see everybody. Mine's, I think in terms of analyzing mine, it's going to be more straightforward for two reasons. One is because my firm did not file the 9/15/14 motion. We're solely seeking fees under Rule 68 from the time that the offer of judgment, which was joint and which included my client, Mr. Ekweri, until summary judgment was granted in favor of Mr. Ekweri, which is in May of 2017. The other reason I think it's a little more straightforward is just the way that our bills are run for these insurance clients. They're a little bit more specific. And of course, I don't represent, there's no other work that we're doing. So I'll just kind of run through this. I don't really have much new to add, Judge, on the entitlement to the fees issue because the issues are so similar. Remember, the claim against Mr. Ekweri is that he, as a security guard, got Ms. Ferris's allegedly defamatory email and then circulated it to a bunch of other people. I don't recall there being any statements attributed to Mr. Ekweri directly that were alleged to be defamatory. So Marvin spent quite a bit of time going through the case law that we rely on as defendants as to why we believe this satisfies the requirements of the statute. I'll just, since it's been a few days, just remind everybody that the law in Georgia is that a nominal offer does not demand a finding that it was made in bad faith. And there's a very, very low threshold to determine good faith, bad faith. And that is if there's any reasonable basis to believe that exposure to liability is minimal, then a nominal offer is appropriate. And when the offer was made, I can speak on my own behalf. I had very much a good faith and reasonable belief that Mr. Ekweri was not going to be found liable in the case for simply forwarding someone else's email. And we were right. The court granted summary judgment, and that was unanimously affirmed by the Court of Appeals. So that's just a reminder of our key points. But since Mr. Pastel's already put those in the record and they're in our brief, I don't. I can just move on to the amount that we're seeking, as long as that's okay.
Sure.
So we did submit an affidavit. I did submit an affidavit before the first hearing. The amount sought in the affidavit, is $17,544. Again, $17,544. Through the line of questioning last time, though, Judge, it occurred to me that perhaps the client, the insurance company that was billed for those fees, did not pay all of those. We all know insurance companies are famous for nitpicking, and so I went back and did that after the first hearing, and there were some deductions taken, and you can tell that it's self-explanatory because in the bills, at the end of a certain month's bills, the very last page lets the client know that one of the previous bills is still unpaid. So if there's a previous amount carried over, then that is submitted at the very end of the subsequent bill. So there were 6 bills that are attached to my affidavit that cover the relevant time period post rejection of the offer of judgment. And 3 of the 6 were not paid in full. There were deductions totaling $114.44 that were reduced from that. So in fairness, the amount that I would be asking for is not the amount in the affidavit because that's actually what was billed, not what was paid. The paid amount, if you subtract the $114.44, is $17,429.56 cents. I'm sorry, $17,429.56. Again, those amounts are set forth in the affidavit and the bills. I just went ahead and did the math of the deductions. So that's in the affidavit. Just about me, I'm a senior partner at Hawkins Parnell. I practiced for 23 years doing civil defense litigation. I've tried 40 to 50 jury trials. I've handled defamation cases. I've tried defamation cases. The rates, I don't think we need to really get into, because my rates and my staff's rates are actually much lower than those that were charged by Mr. Pastel. And I think it was conceded that Mr. Pastel's were reasonable last time at the last hearing. So I would submit that ours, which are considerably lower, are also reasonable. And just a couple of things I'd like to point out, and I can answer any questions that anybody has, is we really tried to be as cost efficient as possible in the defense of Mr. Ekweri. Insurance companies demand that, and they demand that the work be pushed down to the lowest level that it can competently be done at. And so you'll see that in my bills, not all the work was done by me, but it was done either at the paralegal level or the associate level. And while I did not perform all of the tasks, in fact, I didn't perform the majority of the tasks, I think in fairness, I, like Mr. Pastel, get a printout at the end of the month that has the detail of everything that's been put into the computer by my staff. And I review that and I make cuts. If I think something's excessive, I cut it down. But I review it before it goes out, and I supervise directly the people that did the actual time. The other thing is, when these bills are submitted to Arch Insurance, they first go to a third-party reviewing, a bill reviewer, whose sole purpose in life is to cut bills and to find ways in which things were excessive, find an improper staffing issue, duplication of effort, things like that. And so when we submit them, they go to the third party first, and then they get submitted for payment. So I with all humility, I think to only have $114 of reductions on a 17,000-ish set of bills is actually quite good, and shows that the case was appropriately staffed, and that there were it was appropriate amount of time that was billed for these particular tasks. And I think that's it, Judge. I think that covers what I need to cover in terms of evidence, but I can answer any questions, of course.
Okay. Mr. Johnson, this would be your witness now if you have questions beyond what's already been submitted or what Mr. Barr, as an officer of the court, has represented to us.
Sure, I've got some cross-examination, and I'll try to keep it short and sweet.
Okay.
Well, 1 second. Can everyone see this? This is your affidavit, Mr. Barr.
Yes, James, I can see that.
Okay. Have you ever heard the phrase "death by 1,000 cuts"?
Sure.
Would you agree with me from a high level that the vast, if not overwhelming amount of work billed for which you are seeking in 1168 fees are checking emails and looking briefly at documents that come in the mail?
Yeah, that's a large part of what we do. And we've got to review everything that comes in, of course.
So for instance, and I'll point this out if I need to, you build time, or somebody on your team build time for looking at one of Mr. Downs's leaves of absence. Like
Yes.
That's a bill that you charge to your client.
Yes, and it was paid.
And there's a lot of 0.1s, 0.2s for just kind of looking at stuff.
Yes, that's correct.
None of that activity moved this case forward, did it?
No, I don't agree with that. Part of what we do as insurance defense is we've got to be able to know what's going on in the case, even if we're not providing any substance in terms of emotion or something like that. We need to continuously review and find out what's going on, especially when there are co-defendants in the case, so that we can report those to the insurance companies. So it is a little bit different dynamic than when you represent a defendant which is in the case and knows exactly what's going on. Obviously, Mr. Ekweri needed to be kept apprised, but more importantly, Arch Insurance, which insures Mr. Ekweri and his security employer needs to be kept up to date. So a lot of it is just gathering information. Leave of absence is important because we need to know we can't schedule things during that particular time period. We note that on the calendar, and it is a billable task that the client pays for.
So if I hear you correctly, a lot of these time entries are for the purpose of keeping the insurance company up to speed. They're not necessarily important for moving the case forward because you've got Mr. Pastel's firm doing the vast majority of the actual legwork, right?
Well, the second part I agree with, yes. Mr. Pastel's firm did a lot of the legwork, and a lot of it was just kind of us monitoring what was being done. I don't agree respectfully with the idea that that doesn't move the case along. It may not with regard to your claims, but it does with regard to our clients for the reasons I set forth before. And that's part of it. And ultimately, we've got to do these things so that the insurance company can make an educated decision when it comes time to settle a case or let a summary judgment motion go through to ruling. All of this information is important, and the client needs to know it in order to ultimately decide to resolve a case or take our chances on a dispositive motion.
Last question on that point. You would agree with me, and again, I can walk you through these if I need to. There are a ton of review correspondence, review correspondence, review correspondence. There are not very many instances of review correspondence and talk to client, review correspondence and talk to Mr. Pastel. There are a lot of just administrative entries that are literally just someone looking at something. You would agree with that, right?
Yes, there are some quasi-administrative, but one thing that we see, and that's why I mentioned this bill review, LSS, which is Arch's insurance bill reviewer, does not pay for administrative tasks. If there's something that a non-billing person could have done, then they don't pay for it. And they constantly reduce stuff. And again, the $114 is the only thing that was reduced. So this review company has already determined that while these things are somewhat administrative, they needed to be done at the level that they were done.
But not everything in here needed to be done. So let me give you a concrete example.
Okay.
And I'm trying not to get too much in the weeds. Bear with me for a second.
Okay.
Your junior attorney looking at Mr. Downs' leave of absence does nothing to move the case forward or provide a substantive defense for your client, right?
Yeah, maybe I'm confused. I don't understand what you mean by moving the case forward. It's something that it comes in, we've got to review it. And it may take a minute, but the minimum amount of time we can bill for that is 0.1. So, keeping up to date on what's going on with the case does move the case along, because ultimately, as I said before, we have to advise our client, listen, we should just cut this one loose, or let's file a motion for summary judgment and wait for the ruling. So I do think that it is time well spent, and I do think that it is necessary work on the case.
You would agree with me that if I look at a time entry that says prepare a motion for summary judgment, I can see the tangible benefit of that because you won the motion for summary judgment. If you look at a time entry for prepare and take a deposition, that has a tangible benefit because you obtained information that you were then able to use in your summary judgment motion. But things like review file, correspondence with insurance company, those have no tangible benefits or outcomes with respect to the actual case, right?
I don't agree with that. For all the reasons I said before, it's all necessary work to be done in order to obtain the tangible result that we got, which was summary judgment.
Okay, well,
It may not be
point,
working
sorry,
on, I'm sorry, James, I didn't mean to interrupt you.
No,
It may
no,
not be
you're
working
fine.
on the actual motion, but I'm not aware of any requirement under the fee statute or anywhere else that requires work to be, in the affirmative. I think all fees are included, whether you're monitoring work that's being done by someone else or reviewing pleadings that are filed in the case. I don't think it's limited to deposing people or filing motions or arguing motions or the things that you're talking about moving the case forward,
You're certainly not suggesting that if I find an insurance company that's dumb enough to pay me to hire 10 associates to look at correspondence that comes in, and I bill 10 associates for looking at correspondence that comes in, you're not suggesting that I would be entitled to all that time just because people are doing it and an insurance company pays for it.
No, because that would be, what is that, 10 times effort. You can't duplicate effort. That insurance companies aren't going to pay for that. If you can find one that will pay for 10 people to do the same thing,
That's a good point.
Yeah, those don't exist in my world, but yeah, I don't see much, if any, duplication in here, duplication of task. And if there was, it would have been cut.
Okay. Let's look at the last page of this, the last page with time entries. Beginning on May 3rd, you spend a significant, relatively, amount of time preparing a BI claim report to your insurance carrier, right?
Right.
Now, that's something that, other than being a billing requirement and a reporting requirement to your insurance company, has absolutely no bearing on the litigation.
Again, respectfully, James, I don't agree with that. That's the sum that you talk about. We're just reviewing things. This is where we're actually moving the ball forward under your definition, because we're gathering the information for the insurance company, and this is the format in which we educate and update the client. Laura Sassinger at Brownyard is the claims adjuster. We do these periodically. They do take time, but they summarize everything that's been done up until that point so that the client can make an educated decision about the case. So it's something that you would never see, of course. And Marvin wouldn't. This is an internal, basically, communication on our defense team for Mr. Aguirre. But I absolutely believe that it fundamentally moves the case forward.
And on that point, it is something that you don't file it with the court. The court doesn't review it in terms of your summary judgment motion. The court or me or Mr. Richardson can't review it to see if it was really worth the 15 hours or so that you put into it. It's just time that none of us can actually verify, other than just your word that the insurance company needs it, so we did it, right?
Yeah, you can't review it. It's attorney-client privilege, so that's why you can't see it. But again, I have to go back to the fact that this bill is reviewed, and that particular BI report, which the client has, and you can see the number of pages are set forth in those particular entries. This time was not cut as excessive, or for being too long for the report, or being unnecessary, or duplication of effort, or any other reason why it would be cut.
What does BI stand for?
Bodily injury.
There was no bodily injury in this case, right?
Well, yeah, it's opposed to, well, okay, that's fine. You got me on that one.
But that's just the label that would be put because this is a tort claim.
Yes, right. That's what the client wants us to call it. But you're right that technically there was property damage is alleged here, not bodily injury. But it's an ongoing tort report, or status report, or evaluation report. It'd probably be a better thing to call it.
You have, as Mr. Pastel did, you've provided your invoices for the time period in which the 9/11/68 offer was being developed, so to speak, and before it was deemed rejected by Mr. Richardson. And I can walk you through those if I need to, but would you agree with me that there are no time entries by you or any of your team showing any sort of an individual analysis by you or your team of the merits of Mr. Richardson's claim or of your evaluation of a suitable 9/11/68 offer?
Correct, because I don't think we produced, or we're not asking for any reimbursement of time before the offer was rejected, which I think was October of 16. Now, I did produce those two previous invoices to you guys at your request after the last hearing, but I didn't include those because they're not within the appropriate time period. So yeah, I don't, if I understand what you're asking, I think the time that we submitted started to run from after the offer was rejected.
Understood. What I'm getting at is, tell me if I'm right. Your involvement in the 9/11/68 offer that was presented by Mr. Pastel was essentially a conversation with Mr. Pastel where he says, we're going to make a $100 offer, and you say, great, sounds good.
True, but that doesn't mean that I had not done my independent analysis of the chances of Mr. Aguirre. But yes, that's correct. It was a very brief discussion about whether we wanted to join it or not, and I said yes.
And your individual analysis was in your head thinking we're going to win. It's not something that you build time for. Correct?
Yeah, that's correct. I think there's a difference between, because this point was brought up last time, there's a difference between sort of knowing what the law is just from doing these cases for so long and just being able to reach a viable conclusion about what your client's chances are of getting out of the case and doing the work necessary to make that happen. you know, and so I was very comfortable before the 68, even though we didn't put a lot of effort into the offer itself. I very much had analyzed from my prior experience in terms of what you have to prove in order to get defamation before the offer went in. Now, did I bill for a lot of that? No, because a lot of that is institutional knowledge on my part. I just know this from doing it for so long. But, you know, I can't just say, Judge, I'm right about this. You've got to go take the depositions. You've got to file the pleadings. You've got to do the groundwork that we ultimately were forced to do because the offer was rejected. And that's what we're asking for with these post-October 16 fees.
Well, you have to do all that work to develop your defense, right?
To develop, yeah, I mean, that's part of it, but that's not to say.
In other words, if this
ahead,
claim were so frivolous on its face, there's nothing you have to do. You could just file a motion for summary judgment and say, Judge, this is so frivolous on its face. There's no discovery that would ever unturn facts that help the plaintiff.
Well, yeah, but we had to depose the plaintiff. We had to get all this evidence in a form that could be submitted under a summary judgment motion. There's a difference between a motion to dismiss and a motion for summary judgment. This motion for summary judgment requires evidence, and that evidence you can see it in the entries. We had to attend depositions. We had to do things that would not have been necessary had the offer been accepted.
I asked Mr. Pastel this question, and I'll ask you. You did no analysis of, let me ask it this way. The cost of defense of this claim did not enter your analysis of an appropriate 9/11/68 offer, did it?
No, because sometimes we do that. Sometimes we make nominal offers and say, well, shoot, it's going to cost us 10 grand to get this through summary judgment. That money's being spent anyway. Why don't we offer that to the client? I have done that in the past. But what distinguishes that situation from this one was frankly, the borderline frivolous nature of the allegations. Sometimes you just have to spend the money to do the right thing. And sometimes insurance companies do roll over and just give the money for cost of defense, and that's what the offer is. And sometimes you say, you know what, we're not going to do that here. If you're going to force us to spend $20,000 to get summary judgment for a security guard who forwarded someone else's email, then that's what we're going to do. And that was the decision here.
You didn't expect Mr. Richardson to accept a $100 offer, did you?
Absolutely expected him to. I don't know if Richardson or his counsel had talked to Welch, but it's perfectly obvious anybody talking to Welch who was equally accessible to both sides. You talk to Welch, there's no way you can prove the claim. And plus, Ekweri is a little bit different. He didn't author the email that was sent. He simply forwarded it on, which is a whole level removed from the defenses available to Ms. Ferris, which also won summary judgment.
Well, it's interesting that you bring up Mr. Welch because, again, I think we've demonstrated through Mr. Pastel's chronology, none of that information was made available to Mr. Downs or Mr. Richardson until after the 9/11/68 offer was rejected, correct?
Yeah. That's correct. And that's what Marvin covered with the timeline. That's correct. But remember, the complaint alleged that Mr. Richardson lost a financial account. And of course, we know now that was referring to Welch. And I don't think there's any obligation on the part of the defense to show all our cards at the time we make an offer of judgment, including information from Welch. Welch was equally available to both sides. And when I get an offer in, there's a bunch of stuff I have to scramble to do in terms of fact finding, because I need to be able to tell my client this is a fair demand or not. And that includes interviewing witnesses. So if nobody on the plaintiff side talked to Welch during the time that the demand was pending or the offer of judgment was pending, I don't think that obligation is on the defense to educate.
Even though it could, in theory, cut out the need for a lawsuit if you convince the plaintiff of the frivolity of his claims by showing him clear, demonstrable evidence of the frivolity of the claims. You don't think it's their responsibility?
No, I don't. I don't think there's any obligation to you just have to have my understanding, you just have to have a good faith basis to make the offer. You don't have to lay out your case. You don't have to submit every piece of evidence you have. You don't have to do that. And that's just one element of the claim. Of course, that's the causation or the actual pecuniary damage that has to be proven. It still has to be defamatory, and all those facts were equally known to both sides in terms of what the email said and who sent it.
I don't want to get into attorney-client privilege information. You didn't talk to Mr. Akire or Arch Insurance Company about the offer of settlement before it was made, did you?
I did. I may not have billed for it, but of course I did.
When did you do that?
At some point before it was made. there's a lot of, especially at the partner level, there's a lot of phone calls or quick things that I do that I don't bill for because it would be a 0.1 or a 0.2 at my higher rate. And I realize that the client's going to be paying my firm, you know, even in an instance like this, $20,000. At least when it comes to my time, I do many things, including client communications that don't make it to the bill.
Well, I understand that, but then I'm looking at a bunch of time entries where you are reviewing Mr. Downs' leave of absence. So what you just said is not entirely true in every case, is it?
That's true. That's true.
Matt, those
And
are my
it may-
questions.
Okay.
Those are my questions. Thank you.
Okay. Thank you, James.
Mr. Pastel, do you have any questions of Mr. Barr?
Yes, well, I want to get a couple more pieces of evidence in. I can ask Mr. Barr the questions just to get them in. I mean, they're not really about his time entry.
What are they about?
They're just, I want to ask, they would be at Jack Richardson's deposition, we played the audio tape of his voice message. After that, the case wasn't dismissed or dropped by them, but we had to attend 3 depositions.
But
I
just
have
so
the
I'm
motion for
clear,
summary
just
judgment.
so I'm clear, because this is something I think you can
Yeah.
argue when you're providing your summary. Mr. Richardson was deposed in December, several months after the offer of settlement had expired. So yes, it could be dismissed or there could have been new negotiation settlements, but that window of opportunity to resolve the case for $100 was gone, and the 9/11/68 meter was running. It could have been stopped by resolving the case then. And I guess that's your observation, is that you want
Right, and I don't know if, right, I'm sorry, didn't mean to interrupt you. I just didn't know, all I wanted to get in is the time frame of those events. If Mr. Johnson or Mr. Downs aren't going to argue that, and that it was raised on appeal, that it was improperly granted summary judgment, and then to the Georgia Supreme Court, then I'm fine. You know, it's just technically not in evidence before Your Honor, other than some of the pleadings file. But you don't have the appellate brief, like.
I was accepting as valid information I could rely on in assessing your claims and Mr. Barr's claim, the information that you put in red in the email. And Mr. Downs had said he doesn't quibble with the dates that you put in there. He's going to amplify certain things when he makes his argument, but I don't know. You should ask Mr. Barr what you want. I don't think he's necessarily the right vehicle.
Okay.
Well, he may be if he was at the deposition. That's fine.
Well, yeah, no, Your Honor, I'm fine if you're going to accept our representations. You know, that was also in the appellate brief and that kind of stuff.
Okay, got it. Well, then that's it, Mr. Barr. Can we take the documents down now? Great. There's everyone back. Okay. So we've heard from Mr. Pastel. We've heard from Mr. Barr. I don't know that you need to present any evidence, Mr. Johnson or Mr. Downs. You guys are free to argue, but I think we've received the evidence of the billing records. Mr. Johnson has had a chance to highlight concerns about some block bills and where defamation was included and where it wasn't. And I'm still wrapping my head around the timeline because of this change that Mr. Pastel mentioned at the outset of today's hearing. I think I've got it. So I think we're at the point now where people summarize, but I don't want to jump to that if we're not there yet. Was there anything more, Mr. Johnson? We got the presentations, the affirmative presentations from Mr. Pastel and Mr. Barr, the movements. Was there any presentation you were going to make, Mr. Johnson, or is it argument from Mr. Downs?
Argument from Mr. Downs.
Okay. All right. Then my thought is, Mr. Pastel, if you want to present any summary, you want to present your argument without repeating too much what you've already shared, because I've followed that. Now would be the time to do it. Then I'll hear from Mr. Barr, then Mr. Downs. because you, Mr. Pastel, and Mr. Barr are the movants, I'll give you the last word. If Mr. Downs says something, you absolutely need to try to refute it. You'll get a chance to do that. And then I'll take everything under advisement. So Mr. Pastel, why don't you take it from here?
Sure. The first thing I want to clarify, Your Honor, is that what I spoke about first today in any change was the 9/15/14 motion, right? The 9/11/68 remains the same as it always has, okay? And that's the primary focus of this motion. This set of hearings is on the 9/11/68, where we're seeking the $46,000. And if I'm hearing it, the primary focus that the other side seems to be attacking is the good faith basis of making the offer. Okay. First, by beating the spread, the offer comes cloaked in good faith. And what I mean by that, Your Honor, is that Mr. Richardson bears the burden of proving we didn't submit the affidavit, we didn't submit the offer in good faith. And I would also say that you can't lose the good faith argument simply if you have to also lose your opportunity to have a meaningful cross-examination of Mr. Richardson, right? I wanted to be able to cross Mr. Richardson with the audio of that voice, of his transcript and other stuff that was covered, the stuff in his affidavit. And in his deposition, he said, yeah, I remember leaving that voice message. So it's not like it was anything new to him, right? So to have to give him every shred of evidence I have and lose my work product, ability doesn't seem right as the grounds for good faith. And if that audio tape were the begin all and end all, right, it should have ended shortly after Mr. Richardson's deposition. But Mr. Downs moved forward with 3 more depositions. He still fought the summary judgment. We still had the hearing with the summary judgment. And they still filed an appeal on your granting of the summary judgment on the defamation claim. So this whole notion that somehow the audio tape would have changed what they would have done back then, I just don't see how that makes any sense on all the time they spent. Yeah. But again, the real focus is not on whether Mr. Richardson, in his mind, thought he had a good case and wasn't presented with enough evidence at the time of offer of judgment, but it's what did we have? Had we done our necessary homework, right? And as I say, we had all the stuff in the first trial. We had the pre-litigation settlement conference, that they had. And there was a case, I think one of the cases I cite, talk about how having a mediation before the litigation is an important criteria to look at in a nominal offer.
Remind me when was it a mediation or was it a judicially hosted settlement conference?
It was neither. It was the requirement in the condominium documents that they make a presentation to the board.
You discussed that on the 8th. Okay.
Right. So we had that, and I had asked them for information there. Right. I still sent them my 9/15/14 letter, not so much for the 9/15/14 motion, Your Honor, that I'm using it for right now, but on the fact that it raised the defamation issue, and that there was no special damages and stuff. And then there was still the cover letter on the offer of judgment saying, we don't think it was slanderous, and we don't think you had any special damages, i.e. Mr. Welch didn't leave you because of it. It's inconceivable that this offer wasn't made in good faith, right? The fees haven't been challenged on that one, and that's where it stands, right? And I'll rest on what we've already talked about with the 9/15/14. I think it's a proper allocation of time, and it's up to Your Honor's decision on that one to make the call.
All right, Mr. Barr, give me 1 second. Just got to finish my notes, then I'll hear from you.
Yes, sir.
Okay,
Okay, Judge, I'll be brief, since I already did some talking earlier on. But again, I think legally the important thing for us all to remember is that a nominal offer is not automatically bad faith. As long as there's a reasonable basis to believe that exposure to liability is minimal. And with due respect to everybody, there most definitely was a reasonable basis at the time the offer was made to believe that exposure to liability is minimal, especially as to my client, Mr. Ekwere, who simply forwarded somebody else's statements to other people. And as I said before, we most definitely had a reasonable basis. It's true that the majority of the work was done after the offer was made, but as I tried to point out on my exam, there's a big difference between having sort of institutional knowledge about what the law requires and evaluating the basic facts and coming to a conclusion, a reasonable conclusion on whether there's liability or not, and actually doing the work necessary to do that, which is depositions and briefing and monitoring and all those types of things. So I believe, and Your Honor asked these questions, you were focused on the fact that we collectively as defense counsel had this Welch affidavit during the time that the clock was ticking, the 30 days, but didn't turn it over. And as I said in my exam today, I don't believe there's any obligation to do that, to turn over all of our facts and all of our evidence, because you can play all your cards at the beginning when you make an offer, but if it's not rejected, I mean, if it's not accepted, then you've already played your cards and you've given the other side a roadmap as to how to defeat your main points. So, and again, this is not something that we had exclusive access to. Welch was available for both sides to talk to. And presumably Welch is the person identified in the complaint. So he already should have been talked to in terms of whether he was going to provide favorable testimony to the plaintiffs or not. So in terms of my fees, Judge, I think they're exceedingly reasonable, but based on the lower rates, the fact that lower rated people did the majority of the work, and the fact that it passed this arduous bill review process virtually with very few reductions. So I would ask the court to consider that in terms of the reasonableness of the amount that we are asking for. And that's all I have.
Mr. Barr, does the deposition testimony support my recollection that Mr. Ekwere forwarded the email at Mr. Marshall's direction? Or is it that he just sua sponte said, this is a fascinating email, I'm going to share it with everyone?
Yeah, I think it's my recollection. It's been a long time, Judge, and I could be wrong, but my recollection, and the others can correct us, is the former is accurate, that he forwarded it on at the direction of someone else.
Okay, that's mine, and my recollection was that it was Mr. Marshall, and it really doesn't matter who it is. It may matter as I think about things, and I'll have to look at the case law. If Mr. Ekwere was doing it at the behest of someone who was in a position to say, you need to do this.
Right.
Exactly.
I think that's right.
Strengthens your client's position even more, Mr. Barr.
Yes, sir. I agree with that.
Okay. Mr. Pastel, what's your recollection? You and Mr. Downs are closest to the facts and circumstances surrounding all this. What is your recollection as to what the deposition testimony would say as to why Mr. Ekwere, if it was ever asked, forwarded the Ferris email?
If I had to bet on it, I would bet that it was because Mr. Marshall had asked for it, or somebody had from association side.
Got it. Okay. That brings you up, Mr. Downs.
All right. I mean, I'm going to share my screen, so I got a little, so you don't have to just look at me the whole time. Can everyone see that okay?
Yes.
Okay. All right. I want to start by, I guess, saying thanks for everyone's patience throughout this hearing. Is a lot longer, I think, than anyone anticipated, covering the span of 2 days. And nothing personal, Judge, about seeing you in person, but you had said to, try to everyone do the same thing. So since everyone was more comfortable remotely, that's the way we proceeded also.
Not a problem.
All right. guess first off, just kind of quoted this language from this case here. I'll address first the offer of judgment. This is just a policy reason behind the offer. And it's clear that, it's for, the state's intent was for it to be a good faith proposal to avoid unnecessary litigation and to encourage settlement negotiations and settlement, right? It does not mean that, as has been implied, that once we fall within that threshold, it's basically a rubber stamp, that the fee award is mandatory once we recover the percentage less than the offer. Right, you still have to look, the court still has to undertake an inquiry. So what's the inquiry for the court? We kind of put this in our brief, but I want to kind of go over it in a little detail. First, the court has to look at the plain text of the offer. The Tiller case discusses, and we found this in our supplemental response, that before you even get into a good faith, bad faith inquiry, the court has to look at the plain text of the offer to see whether it kind of meets all essential terms, right? And so as far as what constitutes all essential terms, I'll kind of get into that in a little bit. It also has to be clear and unambiguous, right? It's basically basic contract principles. This has to be so clear that if I accept, I know what's happening to my case. And that's the first requirement before you even get into is it nominal or what's this, what's the subjective belief. Second, if we get past the plain text requirement, you do look, in the case of nominal offers, to objective factors of the offer itself. And the objective factors, these are three factors set forth in the Rawlins case. Whether the offer bore no reasonable relationship to the amount of damages, that the offeror had a realistic assessment of liability, and it's also an objective factor that the offeror lacked an intent to settle the claim. And then if we satisfy, those, the court also needs to look to the subjective factors, the offeror's own explanation as to their reasoning at the settlement offer. And so I'll turn to the first one first. The plain text of the offer. Here's kind of the essential paragraphs of the offer from the offer. So the offer is made to resolve the defamation and libel tort claim, count 6, raised against the 3 individual defendants. Keep in mind that there are other defendants that are part of the litigation. The Phoenix on Peachtree Condominium Association is a defendant, as is Mr. Bunkley individually. Those claims had already been, the claims against those parties were subject to the order dismissing those counts. So as the 3 live defendants remaining were these 3, but that doesn't mean that the claims against the association or the claims against Bunkley were forever barred, that they're dead in the water. Those are still claims that haven't been ultimately adjudicated yet. The appellate rights hadn't been exhausted. No dismissal of those claims had occurred, by Mr. Richardson with prejudice. So those claims still theoretically were kicking, not procedurally barred. In full and complete settlement of the tort claims, and again, I mean, it's nomenclature, but if you look at the case law, the nomenclature is very important in these offers, and the Court of Appeals looks at these things de novo to make sure the offer would be clear. But here in paragraph 3, they're referencing claims. Previous paragraph reference 1 count. So that's an argument. And then I think most importantly, there are no conditions on the offer. So as a practical matter, what happens if, Mr. Richardson is inclined, to accept this offer? Based on the case law, what he's supposed to do is get presented with an offer that's so specific that he knows exactly, what happens if he accepts it or rejects it. But in this case, with no conditions, if he accepts the $100 offer, that doesn't procedurally dismiss any claims. And if it were just a simple case of, I've got a tort claim, a slip and fall claim, a single count complaint against the defendant, and it had no conditions, and I accepted it, I think you'd still be fine. Obviously there's only a single claim there. So if I accept it, I'm gonna, for all intents and purposes, assume it's dismissed. But in this case, we've got multiple claims against multiple parties, some of whom are part of this offer and some are not. So I think it's reasonable to look at the fact that Mr. Richardson could legitimately be confused about what happens to the case in total if he accepts this $100 offer. Because
I can't raise my hand because we're just on the screen, so I just verbally
I can see you, Judge.
apologize. But this doesn't say it makes the whole case go away. This says that count 6 will go away. My words, it doesn't say go away, but it will resolve count 6. First paragraph, it's actually paragraph 2, says it will resolve count 6. So the 3 defendants will pay a total of $100. It's not $300, not $100 each, but $100, and that will resolve count 6. What's the uncertainty generated by that? It doesn't say anything about counts 1, 2, 3, 4, or 5. I can't remember, but I suspect there were counts beyond count 6, like punitive damages and things like that. But this doesn't address those. I know some had already been dismissed. And maybe by this point you had withdrawn the assessment allegations. But regardless, if all the other counts were alive and kicking, what is the uncertain part, the unclear part of this offer to resolve count 6 for $100?
And again, what I would submit, Judge, is it's unclear whether it actually gets resolved based on this offer, right? I mean, I accept it, but I'm under no responsibility to dismiss any claims or enter into any mutual settlement agreement or release of claims.
Okay.
And the litigious nature of this lawsuit between the parties. I mean, it's certainly reasonable to be suspicious about that, to wonder what the practical effect of doing this is. Certainly with the defamation count, Judge, that includes some serious character allegations against Mr. Richardson. It's reasonable to think that he would want a release and a non-disparagement for any sort of future allegations. There's no conditions upon this, Judge, and so it's reasonable for him as the non-lawyer litigant evaluating this offer to be confused as to practical effect in a multi-count, multi-party lawsuit when some claims have already been dismissed, some claims remain pending, to be confused about whether his acceptance of this offer, concludes the claims that they're supposed to conclude.
So what does the case law say about situations of potential confusion? Mr. Barr and Mr. Pastel have argued we didn't have an obligation to push out information about Mr. Welch and what was going to go into the affidavit, even though we knew it, that was accessible to all. So they're saying no obligation. Does the law put any obligation on you, Mr. Downs, if confronted with the confusion that we've refined this down to? And the one that I find persuasive is, well, what does resolve mean? It actually doesn't say dismiss, probably should have, it doesn't. And I think you have been gracious in describing this as parties who are particularly litigious. I would think that people would want it nailed down. It will be dismissed by 3:15 p.m. on October 11th. We'll all be in court as the dismissal is handed in. So there's no doubting about who's hiding what. And this doesn't say that, but you could have asked, what do you mean, Mr. Pastel, by resolve? I trust you mean dismiss, even though it doesn't say that. Could you send us a new one that says dismiss? I suspect you didn't have that conversation. Is that Mr. Pastel's problem or is that your problem?
Judge, I believe the law places no burden on the person presented with the offer to do anything other than accept it or reject it on its own facial terms. There's no requirement that any digging behind the curtain be done, any further fleshing out. It's an offer acceptance situation. The offer of settlement is designed to stand on its own. It's to be a standalone, and that's why the Court of Appeals reviews it. They know, from the face of it, does it stand alone in the context of the litigation? And if accepted, does it do everything that the parties intended to do?
Okay,
Does that answer your question, Judge?
it does.
So, for those reasons, Judge, in this case, and we cite a couple of the cases that have looked at this situation and have reversed awards of attorney's fees on the offer of settlement. There's the Tiller case, and there's the case metrics case. Both of those cases are situations, and they're factually different, right? I mean, the different claims, different parties, obviously. But the fact that, the one fact that is similar, right, is that they involve multiple claims, multiple parties. And I think that's the key issue in this case that makes it confusing and unclear, is that when you've got multiple parties and multiple claims, and they've been in litigation before, and they'll still be in litigation after this if the offer is accepted. What is the person presented with the offer supposed to do about that? Are they supposed to wonder or guess? And the case law says no. The case law says if when presented with an offer, all the material terms should be so clear that when I accept it, everyone knows exactly what happens with the case.
But apart from the verb resolve, what leaves you uncertain about what's going to happen to others? It doesn't talk about others. It doesn't talk about count 7. It doesn't talk about count 2. It doesn't talk about the other defendants in the case. And so it would be an odd interpretation by the recipient of this offer to think, this covers the other counts as well. I accept, because it doesn't say that. So I'm hearing you with the verb resolve, and I'll need to think about that and look at the case law about the degree of precision required. But I'm not persuaded by the uncertainty about what happens to the rest of the case. He might well be uncertain, but Mr. Pastel and Mr. Barr, through this offer of settlement, aren't touching anything other than count 6. And I hear you that in paragraph 3, it says claims and not claim. I wouldn't emphasize that argument again, but it's confined to count 6. It doesn't extend any further.
Well, I think that what makes this one problematic is the fact that there are no conditions, right? And the fact that there are no conditions, I don't even have to dismiss the claims, nor do I have to enter into any sort of release agreement with these parties who I've been at odds with for so long. There are no conditions upon accepting this. You can see how Mr. Richardson would be genuinely confused when presented with such an offer. And what it goes to, Judge, is the policy behind it, right? If a party was seriously concerned about making a good faith offer to resolve the case, to resolve the litigation, and was not just setting up a fee award, if the goal was really to present a good faith offer and to advance the state's public policy, then clearly you would specify, in the offer what happens with regards to these claims. They get dismissed with prejudice within a certain number of days. Subject to mutually agreeable language, the parties would enter into settlement or release agreement, covering these defamation claims so that no one would have to wonder about getting sued for defamation going forward. And Mr. Richardson likewise would have wanted some sort of protections in there about being countersued by association or any sort of non-disparagement. So I think that the fact that there are no conditions this is certainly problematic in the context of these proceedings. And I think, based upon the case law that we've cited, in a multi-party, multi-count case, when there's no such condition and no specificity on this offer, I think it renders it defective, Judge.
Okay.
Unless there's any further questions on that regard, I'll move to the next point.
Next point.
All right, so then we get into the objective factors, right, Judge? And I don't think there was any dispute by any of the attorneys in this case that it was a nominal offer. We heard, a lot of talk about how nominal offers are okay. Nothing inherently problematic about a nominal offer. And while that's true, based on the objective factors, we do pretty quickly see the problem with this nominal offer. Mr. Pastel's testified, and the time entries reflect that they did no calculation of damages regarding Mr. Richardson. They didn't get out the calculator. They didn't assess the damages. They didn't consider their defense costs. Neither Mr. Barr's firm nor Mr. Pastel's firm considered any cost of defense in making this offer. And I think that's very interesting. I mean, from a good faith, bad faith standpoint. I mean, if we're really looking at this as advancing a public interest in getting this case that's clogged up Your Honor's docket for so long off the books, and we know we're going to take some depositions, and we're going to, we have to do this to file summary judgment. No consideration at all of those costs in trying to make this claim go away. I mean, I think that's certainly a defect in the offer. We looked at Mr. Pastel's testimony right around the time of the offer. The time entries reflect no review or research of defamation law, nor to Mr. Barr's records. I understand, Mr. Barr testified that he had experience doing that, but you're not going to double check, make sure the law hasn't changed in the last couple of years since your last defamation trial. I think that's what any prudent attorney would do in advancing a good faith offer. Is there would have to be something you would want to see related to, we're going to present this offer. This claim is so significantly defective, and I just want to double check and make sure there's nothing in that regard during the applicable time period when they're doing this. No discovery responses were received from Mr. Richardson during the time period of the offer. They had nothing to go on, no deposition transcript, no even interrogatory responses for them to evaluate, the merits of his claim, the dollar amount of his claim. And you heard Mr. Pastel's testimony under cross-examination, hadn't even discussed, with their client, how they were even going to pay the offer. And that's one of the elements, Judge, is whether they even intended to settle. I mean, this was a purely attorney-driven settlement offer, right? And so therefore there's, and because of that, there was not even a consideration as to whether the client was going to be on the hook for the check, the attorneys, or anyone. This was purely an offer designed to set up a subsequent fee awards claim. Here's a blow up of one of the time entries from Mr. Pastel's firm. You'll see that Your Honor's order on the motion to dismiss comes in on the 12th of July. And a mere 10 days later, Ms. Harrison is drafting the offer of settlement, starts to draft the offer of settlement. The only reason that it was even a 10-day delay is because we had petitioned for a certificate of immediate review. And you can see that on 7/21, Your Honor denied that. So immediately, Ms. Harrison sets to work on how can we set up this fee claim award on behalf of the defendants going forward. There's absolutely no no review of the applicable law, no review of discovery, no calculation of damages as we mentioned. Just it's a simple what's the soonest we can try and start the clock on this.
Am I misremembering? I thought that Mr. Pastel had sent long before all this. I think he calls it his 9/15/14 letter, but it was a fairly detailed letter saying politely, Mr. Downs, here's why you're going to lose, claim by claim. So are we ignoring in looking at the entries that you want to focus on? I understand why you're focusing on them, but are we ignoring an investment that had been made in the past that maybe the defendants thought would be successful in the motion to dismiss? It wasn't. Some things survived that motion, but nonetheless should be credited to steps or efforts that the defendants undertook to get a sense of their liability, the likelihood of success for plaintiff on any claim that might survive the motion to dismiss?
I don't think so, Judge. And I mean, here's why. I mean, if that were the case, and I'll go to the next slide. This is the one time entry that we could find that related to any research on defamation law. And Mr. Johnson, questioned Mr. Pastel about this, and he tried to characterize it as, well, there's other time entries that we would have spent on defamation, but there's no objective way anyone can look at his time entries and see that. Nothing at all relates to the defamation claim in any of his other fee entries. So, assuming that to be the case, Judge, assuming we're going to give him credit for he has done some prior research, it's related to this April 4th block bill entry that includes every count in the entire case. And we don't go back over it in July. Nothing, after Your Honor denies them summary judgment on the defamation claim, there's no revisiting of that issue as to why we lost. What's our potential exposure? Are we missing something based on our prior research? No review of the prior law. And certainly no memos to the client, no discussions with the client whatsoever about the law, about why we didn't win on this one. We got everything else, but we didn't win on this one. So I don't think we can say just because at some point 3 months before, actually, since the offer was the end of August, it would be from April, from beginning of April to the end of August. We can't say just because you did some research that long ago, that shows that you acted in good faith, considering the circumstances, Judge, considering all the litany of problems, with the offer that they made. I don't think that's any sort of saving, provision in the agreement that allows them to say, see, we did act in good faith. We didn't act in bad faith, because we don't know if it was a 0.1 on defamation, or anything else. And we have no way of knowing, other than this one block time entry, how much effort went into researching defamation, and certainly not analyzing defamation in light of Your Honor's motion to dismiss order on the motion to dismiss.
Okay.
One thing that we do see during this time period, and I didn't highlight it for purposes of emphasis, but one thing we do see during this time period of the offer of judgment is what the association, they were concerned about a number of things, not reviewing, not researching the defamation law, not calculating any damages. They were certainly concerned with filing a bar complaint against me. There's definitely time entries related to that. They were certainly concerned with, WSB TV report where Richard Belcher exposes him for not paying water and sewer bills. There's a lot of time entries related to that. So I guess we can understand.
None of that is something that is that Mr. Pastel is seeking to get Mr. Richardson to pay for.
No, I'm just saying, I'm offering by way of context for what for what actually was going through, for what they were doing at the time, instead of evaluating a good faith offer. And then Your Honor asked about the timeline. Well, here's the timeline, and I don't, this is what I compiled. The only difference I think is that our discovery responses were served on the September 2nd. They say they didn't get them until a few days after, so I don't doubt that. But regardless, it's after the offer is sent, right? And so I think that's the concern that we have, and I think that the concern that would exist under the law is at the time of making the offer. It's not what we learned after the fact. It's what we knew at the time of the offer. We didn't have the Welch affidavit. We didn't even have the Welch recording.
What's your response to Mr. Barr's argument that no, you didn't have it, not their job to hand it to you. You proceed with the information you have. There may have been strategic reasons to share it, to let you know how reasonable the $100 offer was. There may have been strategic reasons not to share it, but there's not an obligation to, and they certainly were not sequestering Mr. Welch so that during the pendency of the offer, you couldn't find him to ask him that real important question, which is, why did you and Mr. Richardson break up? You learned much more about it in December, long after the offer had expired. But that was, it seems to me, knowable information before the offer was made, and certainly during the pendency of the offer. So how do you respond to Mr. Barr's observation?
I think what we're talking about, or at least I'm talking about right now, and I'll address that second point, but what I'm talking about right now is the factors that led to the defendants making an offer, right? So the relevant point in time is up until August 31st at this point in time. This is what they have to show, a good faith, basis for making the offer. At the time that they made the offer on 8/31, they didn't have any of this stuff. They didn't have the voicemail, and they didn't have the affidavit showing the claims were, that the damages weren't what Mr. Richardson thought. Right. So I think that's the relevant inquiry for the court.
Okay.
Not, well, when could he have known after the offer was made? When could Mr. Richardson have known after the offer was made? We're now looking at the offerer at their state of mind, at what they're doing, at their good faith basis, right? So at the time of the offer, they didn't have any of this information. They didn't have, and so to break it apart, the information that first came to light is the voicemail itself, right? I mean, the voicemail itself, that's not conclusive one way or the other on what they're trying to say it stands for. They're trying to say it stands for the fact that Mark Welch, clearly, terminated his, accounts with Mr. Richardson because of the voicemail, but that's not, he didn't aver that. I mean, that's just a voicemail from Mr. Richardson.
Well, either way, the voicemail Mr. Pastel did not have until after the offer of settlement was made.
That's right. Yeah, he didn't have it until afterwards.
Okay. We can disagree on what that might tell you about Mr. Welch's interest in working with Mr. Richardson, but Mr. Pastel didn't have it until after the offer went out.
That's right. It didn't have the affidavit until after the offer went out, several weeks after the offer went out. So at that point in time, the time the offer went out, it wasn't like he was working on the affidavit with Mr. Welch and had this in his back pocket and was going to, knew that there was absolutely no claim that Mark Welch, had any damage. Mr. Richardson had any damages associated with Mark Welch's account. That's not what happened. Didn't happen until after the offer. And then again, the affidavit wasn't even presented to us in this case until their summary judgment motion after all discovery had been conducted. Right. So if, the point about I'm setting up a fee award, that's the perfect roadmap for doing so. Right. I have an affidavit that's, important, in the case. I'm sitting on this affidavit, and I'm going to allow all discovery to commence and be conducted. And then the close of discovery, after I've incurred all my attorney's fees, now I'm going to disclose the affidavit to you. And that's what happened in this case. It was the affidavit, which is, the first time that Mr. Richardson was aware that Mr. Welch had said, I terminated my account for different reasons, came at the time of filing the summary judgment motion. And finally, Judge, the subjective factors that we had talked about earlier. This goes to the offeror's intent on settling. We've kind of touched on some of these things before. Mr. Pastel, was very clear that his client had no input into the settlement offer, right? That he just discussed the quote mechanics of the offer with his client. Your Honor would surmise that's really just, what this is going to mean if he doesn't accept it and we get a summary judgment that we get all our fees after this. The mechanics being the operation by law of we're going to, get the attorney's fees awarded to us if he doesn't accept this $100 offer. He talked about what evidence the association had when they were presenting their offer. Some of the things I wrote down that he's talked about years of prior conduct. That has no bearing on the evaluation of Mr. Richardson's defamation claim. Everything that came up at the first trial. So what I heard when I hear that is, yeah, we spent a lot of fees, a lot of attorney's fees in litigating with this guy, a lot of which were our own fault for the first litigation. Now we're incurring additional fees. This is going to be a chance to catch up on some of that, to recover some, to show our, our dues paying owners that we've recouped at least a little bit. The time entries themselves don't show any of the substantive analysis, don't show any of the explanation. Mr. Barr, based on his years of experience, he's just going with his gut, and based on his years of experience, he didn't review any of his BI reports. He didn't put any additional memos together. He's not coming up with anything else that would lead them to make this good faith offer. And so I think based on their own testimony, both attorneys, based on the fee records, and based on the objective factors in the context of this nominal offer, we can clearly see that this was a bad faith offer. That this was not presented for purposes of genuinely trying to resolve a dispute. This was simply something to start the meter running on a subsequent attorney's fee award that they would consider to be mandatory.
Mr. Downs, I can't remember. Did you ever respond to the offer, or the offer simply expired?
The offer expired, Judge.
Okay.
And so in sum, Judge, I would just, point to the Eagleman case, which is from the Florida District Court of Appeals, but is a very similar kind of, not necessarily fact pattern, but essentially what happened is somewhat similar to this case, right? Same $100 offer in that case. The offer was submitted in that case at the time the answer was filed by the defendant. In this case, it wasn't sent at the time of the answer, but essentially the soonest point in time at which, any remaining claims remained, right? Certainly before any discovery. Both offers were sent, before any discovery had been conducted or received. And it was based on the parties' own subjective belief that they weren't liable. And I don't think we've heard, any testimony to the contrary before the proceedings here. Both attorneys talked about, we just didn't, this just didn't seem like we were going to be liable for this. There's nothing concrete we can look at to say that they analyzed this or that they seriously discussed it with their clients. It was pretty much a subjective belief based on, been doing this for a long time, that this is what we're going to offer. And so in that case, the award was struck down because of really the court there. I mean, this offers really simply, a predicate for a fee award. This isn't furthering the purposes of the statute in resolving disputes. This is being used as a sword by attorneys to try to saddle parties that feel like they have legitimate claims, attorneys. Unless there's anything else on 68, Judge, I was going to move on to 1514.
Let's do that.
Okay. So fees are sought in this case under both 1514A and B. Under the law, it's they're arguing that because these claims were dismissed, therefore we should be entitled to our fees, and I guess it's continuing to be revised downwards, I guess, based on what claims we can recover for. But it's not 91514A doesn't no award should be done under 91514A about cases that are questions of first impression, about reasonable minds may disagree, or claims that find support, even limited, in existing case law or statutes. Based on Your Honor's own orders in this case, Your Honor found scant guidance on the abusive litigation issue, as opposed to who prevailed, who didn't prevail, based on the case law. Admittedly serious allegations that Mr. Richardson raised for his IIED claim. And then a bulk of the claims that were ultimately dismissed, Judge, kind of involved this procedural issue as to whether the claims were compulsory or permissive. Again, a legitimate dispute. I understand it didn't go, our way, and the Court of Appeals agreed, but it doesn't mean that there wasn't some lack of clarity in the law based on whether these claims were compulsory or permissive. And then as far as the negligent hiring claim, there was some legitimate arguments we had on the impact rule. So it's not like any claims here were asserted without plausible factual basis, right, or plausible legal basis. And so there's nothing in there, nothing in 1514A that would merit any award fees in this case. And for B, as Your Honor knows, I mean, that's a discretionary standard. A is mandatory. If they meet that criteria, the court has to do so, but B is discretionary. Even if the court were to find that, the claims, didn't meet this, didn't meet that standard, that, the court still has discretion under 1514B to award these. And what I would simply point out is for the same reasons we articulated in our prior brief on this issue, there were plausible factual and legal basis for arguing these things. But another thing that 1514B talks about is that, fees are appropriate against someone who unnecessarily expands the proceedings. So what did the movements that are seeking fees in this case do? I mean, we didn't file for 91514. I'm just pointing out this by way of illustration. They had the Welch affidavit throughout discovery, allowed depositions and written discovery to take place, before acting upon it to file a motion for summary judgment. And so now, what they're doing is they're trying to get the benefit of their own bad acts and kind of hide it. And there's no requirement that they have provided this affidavit, as Mr. Barr said, as this litigation strategy. But at the same time, it seems in bad faith to now claim that, even though I had this thing that I could have filed a while back, based on, all this extensive defamation experience I have, I'm still going to allow, months and months of discovery. Nothing requires you to wait until after the close of discovery to file a motion for summary judgment. You can file it as soon as you believe the facts and law are undisputed and on your side. And that's not what happened here. And so I'll point that out simply by way of illustration as a further support. And again, I think it's interesting and important to note also that co-counsel didn't join in Mr. Pastel's terms, 91514. motion. Mr. Aquarius counsel, didn't file its own motion or move under the statute, whereas they did under 1168. And I think that's telling as well. I believe they made the assessment that these, the conduct of this litigation didn't warrant fees under either of those subsections of 915.14. The other thing I'll add, kind of in summary thing, is that, and I'm not going to go line by line on the time entries themselves, Judge.
Good.
All I would say is, if Your Honor is inclined to undertake that exercise, in going through the time entries and believes some fees should be awarded, that we would be allowed an opportunity to submit written findings on why specific entries aren't appropriate within this. Because I believe there's categories of things such as discovery disputes that are included within the time entries that shouldn't be recoverable under any theory. So I would just, instead of going line by line, I would just ask for the consideration in that regard.
Okay.
I believe it was in some of the communication that Mr. Pastel set forth, was that they're only seeking a fraction, of the fees that they spent on this case, Judge. That there was somewhere over, $200,000 in fees that they've incurred since this, I would say, second lawsuit originated. And Judge, if that's the case, if that's how much they spent, and the offer was $100, I think that ends the issue. That they're willing to spend, that much money on a case, and that's all they're going to offer, and they think that's good faith. And so I just wanted to conclude, and this may not be the appropriate forum for this, Judge, but one of my thoughts on this getting before Your Honor was like, let's use this as an opportunity to try to just end all the litigation,
But I'll miss you guys.
Yeah. And so I would just point out in that regard, Judge, that Mr. Richardson, and I don't believe this is a disputed fact, moved out of the condominium in April 2018. Hasn't lived there since then. I reached out to Mr. Pastel about agreeing to submit a request that Your Honor lift the injunction that's in place in this case. Mr. Pastel didn't want to do so as long as the litigation remains pending. I don't necessarily agree with that, since one of the whole purposes of it was because of the close proximity of the litigants, but nonetheless, we haven't wanted to burden this court with separate ancillary hearings on trying to lift this injunction. But if Your Honor needs something more formal to do so, other than this verbal request, I would just simply say, I'm really just pointing this out to the court just by way of housekeeping, that this is still on the books.
Is it in the 2013 case?
Yes, Your Honor.
Okay. Okay.
And that's all I have, Judge.
All right. Well, that was a lot. Thank you. Mr. Barr, do you have anything you want to say in rebuttal? Oh, I'm sorry. You're on mute and you just disappeared.
There, can you hear me now, Judge?
Yes, sir.
I'm sorry. That's weird. Okay, there I am. You can hear me. Just two quick points, Judge. First is that I thought, and maybe I misheard, but I thought Mr. Downs said that we racked up the majority of our attorney's fees before the deposition of the plaintiff And that's just not true as to mine. I just was counting as we were sitting here. There are 29 pages of invoices that I submitted. In the entry where I said I attended the deposition of Mr. Richardson is on page 2. So the vast majority of the time that I put in the case was after the deposition of Mr. Richardson, where this voicemail was played. And you know, once this voicemail was obtained and the affidavit was submitted with the summary judgment motion, you saw what happened, Judge. It had absolutely no effect on the case. It kept going all the way through summary judgment, kept going through the Court of Appeals, went all the way to the Supreme Court. So the idea that, gosh, if you had just given us this affidavit, this whole thing would have been over I think if you consider all the circumstances, that's a real question, is if we had produced this information, would it have resulted in any different outcome? And at no point, to my knowledge, did the plaintiffs ever come back saying, gosh, you got us on Welch, there's no way we can win, can we have that $100? To which we would have, of course, we would have paid the $100. So I think if you consider the conduct that, or the events that took place after all this information was available to everybody, and then ask the question of whether that actually would have made any difference. That's my only point. Thank you, Judge.
You're welcome. Thank you. Mr. Pastel.
Yes, I'll take it in order that it was presented. The first was about the wording of the offer of judgment, and it's simple, Your Honor. There are no conditions stated in the offer because there are no conditions. That's it. You know, it's over, right? We pay the $100. We don't want to hear about this defamation claim in this lawsuit again, right? What they want to do with it, I don't care. I just don't want to hear about it. If for some reason, you know, this has no bearing on really our validity of ours, but since so much time was spent on about Mr. Richardson's mindset, and maybe he wanted some sort of release, right? They were free to send an offer back for $100 or for you pay us $100 and include a release. You know, I mean, there's plenty that Mr. Richardson could have done if he wanted extra conditions. I don't want conditions. I just wanted it to be defamation done with, no conditions. Then we go on to those 3 factors for a nominal judgment. And all they have on the what about the cost? All they have is, well, you would have had to pay a lot of defense costs, right? They don't deny we nailed it, our decision on the actual damages. Now they're trying to say, hey, but you're kind of being held as a litigation hostage, so you should have to pay to get out. And that's really how I view that argument, Your Honor, that, well, you're going to spend a lot of money defending the case, pay it up now in the offer of judgment, right? That's uncalled for in my book. Then they talk about research. As I said, whether it's identified in the time entries or not, we had our letter to Mr. Downs, we had our motion to dismiss, and everybody had Your Honor's order, right? And again, Your Honor orders stated, right, was the roadmap to everybody. Quote, here what defendants are deeming to be opinion is the author's assertion that the plaintiff suffers from an, quote, erratic and scary mental health issue, end quote. That requires him to take, quote, meds, end quote, to control it. Such a claim on its face is capable of being proven false. Presumably, plaintiff, if he does in fact enjoy good mental health, offer up expert testimony to that effect. Because defendants have not shown that the plaintiff could not prove the falsity of the offending statements, their motion to dismiss the claim of defamation of libel is denied. And that's the end of your quote on the order there, Your Honor. A clear roadmap as to what Your Honor is looking for, right? And that's why I talked about the relevancy of all the prior transactions with Mr. Richardson on whether he does in fact enjoy good mental health. on that issue there. And then they move on to this good faith. And it's worth quoting again from Smith versus Fortnier, 629 Southern 2nd, 1036. Good faith does not, quote, demand that an offerer, us, necessarily possess at the time he makes an offer or demand under the statute, the kind of quantum of evidence needed to support a judgment. The obligation of good faith merely insists that the offerer have some reasonable foundation to base an offer, right? And again, right, I don't think it requires like either, I can't quite think of the game, but maybe it's bridge where you got 4 books left and you just lay down your hand and say, I get the last 4, look at my hand, right? I don't think the get good faith, I have to show and say, Mr. Downs, come and look at everything I've got, right? Right, even my work product. Right? In discovery conducted, we had, as I say, I won't conduct discovery, but really, on my final comment on both this and the 9-15-14 motion, here's what I keep on hearing about the bad faith, right? It kind of reminds me of being in elementary school and everybody's supposed to turn in their homework and only one person did their homework, right? Got the affidavit, spoke with Mr. Welch. Only one person did. And everybody else in the classroom, the students, are mad because that person makes the rest of them look bad because they didn't do the homework, right? This idea that because I did the homework, right, I'm the bad guy is just, I don't even understand it. So I'll leave it at that. Thank you.
You're welcome. Well, I think that's it. We have very thoroughly covered the motions for attorney's fees. I have a lot to digest. Mr. Downs, could you email to Ms. Niles the PowerPoint that you put together or whatever the piece of software was?
Absolutely.
Okay. Let me just make sure I'm covering everyone. Mr. Barr, do you have anything procedurally? We're done with the argument, but anything else we need to touch upon?
No, sir.
Of your client? No, sir. Okay. Mr. Pastel, anything else on behalf of your clients?
No, Your Honor.
All right. And Mr. Downs?
I do not.
Okay. Well, thank you everyone for your time. Thank you, Ms. Rabsat, for doing your good work there. You need to, lawyers, you need to settle up with her. This has been pushed out on YouTube, and I know that's recorded, but the little icon has been on the whole time that the Zoom session is recording as well. So Ms. Rabsat, if you need a recording of this for the work you're doing, you can reach out to Ms. Niles, my staff attorney, and she can help you get that. You're welcome. All right. Thank you, everyone. Have a good rest of your week. Bye-bye.
Thank you, Judge.